Okay, wonderful. We've completed almost half of our chapter. Okay, we've completed everything with respect to administrative law. And now we're coming to the next most important topic, and that is your principles of natural justice. What is this principles of natural justice? Will you find it in any law? Is it a section number? Or do you find it in the Constitution of India? The answer is no. You will never find the word principles of natural justice used in any wordings of any law. Then where did it come from, ma'am? It comes from a interpretation of our courts, the interpretation of Article 14 and 21 of the Constitution. Now, it's a very interesting concept, okay? And for this, let's try to understand it a little bit in a little bit of detail. Now, one fact that you should be aware of is that here I'm going a little bit off topic over here so that you have better understanding. Now, let's say we have a court of law, okay? A court of law is governed by the Civil Procedure Code. And I'd like you to write these points down with me. The Civil Procedure Code is the law that governs the procedure to be followed in the civil courts. Now, what is a tribunal? Okay, a tribunal is an alternate to the court. Okay, a tribunal was set up simply because we had some problems, and that is the courts were insufficient. There was too much excessive caseload, not enough judges, too lengthy process. Okay, maybe let's write that down. The problems of the civil court was that, one, there were less judges, so we didn't have enough judges to handle the caseload. Second, the caseload was very, very high. Caseload was extremely high. And more importantly, very lengthy processes. Lengthy process. And so they say that justice delayed is justice denied. But what to do? The processes were extremely lengthy. The minute you have to go to a court of law, you know that you will be spending a minimum of 1 year to even 2 years before the court of law. Okay, that is why, as an alternate, there were many solutions that were brought in. One such solution was a tribunal. Okay, so what exactly is this tribunal? Is that it is like a court of law, and the only thing is that it is not governed by the civil procedure code. It is not governed by our evidence law, a current Bharatiya Sakshiya Adhiniyam, but what is it governed by is the principles of natural justice. PNJ. From here on forth, I'm going to call the principles of natural justice as PNJ. So now can you understand the concept? We have courts, but it's not sufficient to take care of our caseloads. So tribunals were brought in place. But quickly let's try to understand how are tribunals existing? Especially because we're saying there are less judges. If we don't have enough judges for our courts of law, where did we get our judges from our tribunals? Now, the tribunal is an interesting concept. It doesn't consist of only the judiciary. It consists of one judicial member, okay, and it consists of one technical member. Technical member is from no one other than the executive body of state. Now it makes more sense. And the judges, when we say judicial members, they might even be retired judges, okay, and they are no longer part of the judiciary, and now they have come to the tribunals. So look how our judges problem is now solved. But what is our main thing? The executive is here. The executive is here also in the tribunals. Now, this is solving our problems, but remember, our civil procedure code gives one process. And let's write down this process over here for better understanding. We will study about this in a lot of detail when we're looking at the CPC chapter. But essentially, one of the first things that our civil procedure code says is that you have to send a notice to the other party. Okay, you have to send a notice to the other party. Okay, and both parties will be heard. both parties will be heard. So that means the complainant will come and complain to the judge. The judge will send a notice to the defendant, and the defendant will also come before the court of law, and both of them will be heard. But what do you mean by being heard? Basically, they will present the facts, okay? They will present their arguments, they will give all the evidence before them. Now, one party will come and give evidence, the other party will come and say, no, this is wrong evidence. So that means evidence can be rebutted. Rebutted means challenged. If I'm coming and giving an evidence, then the other party will come in and say, no, this evidence is false, it's forged. So, point is, evidence can be challenged by both the parties. Similarly, arguments made by one party can be uh, can be countered, can basically be countered, or counter arguments can be given. Then there's something known as cross examinations. Okay, that is, the opposite party will cross examine the plaintiff, and the plaintiff will cross examine the defendant. If I'm going a little fast with this process, don't mind, because this is a process that we are studying through CPC. But essentially, this is the basis, like a summary of what happens before the civil court. And then how can we forget our most important thing? The final decision will be given by the court of law, right? Now, this is a process that is required to be given by our civil procedure. But what did we see over here? Before the tribunals, the civil procedure does not apply. It does not apply. And more importantly, evidence law also does not apply. Great. Now, what applies then? So that means in tribunals, you don't have to send notice, you don't have to hear both parties, then you don't have to give arguments, you don't have to give any evidence. Evidence can, you can just come and give whatever evidence you feel like. No cross examination. Forget that. Judge need not even give a decision. Great, no? Obviously not. Then what is the point of the tribunal over there? The purpose of the tribunal is to reduce the caseload of the courts of law. So this is where the concept of principles of natural justice comes in. Okay, and let's look at the principles of natural justice first before we come back to this point. Now, principles of natural justice can be clubbed under two main headings. What are those headings? Is first one we'll go to the rule of fair hearing, also known as audi alteram partem. Let's repeat it again. The rule of fair hearing, audi alteram partem. What is audi alteram partem? It's a Latin word. Okay, what is this principle saying is that no person should be condemned, no person should be held guilty without being heard. Okay, this is one of the most important principles of natural justice. The next principle that we'll be looking at is something known as rule against bias. So let's, what does why do we say rule against bias? The Latin maxim that we see is nemo judex in causa sua. So let's repeat it again. Principles of natural justice has two main headings. First one is audi alteram partem, the right to be, I mean, no person shall be condemned unheard, or the rule of fair hearing. The second one is the rule against bias, nemo judex in causa sua. Wonderful. Okay, what do you mean by this rule against bias? Now, rule against bias is saying that no person should be a judge in his own matter. What does that mean? Let's say, for example, that I have a problem. I have a problem with you. Now, the problem may be it can be a small dispute between us. So, will I be the will I be the judge in our matter? Will I itself decide to give final judgment in this matter? No, right? We will go to a third person. We'll go to a friend, or we'll go to a related person who can solve the dispute for us. But why? Why do we need to involve third people over here when we can solve the matter ourselves? Because the third person is an unbiased person. They're not interested in who is deciding this dispute, right? And in a way, when you look at it, if you go to a court of law, the judge is an unbiased person. The judge is usually someone who is an independent person who decides the matter between two people. The same thing applies even in principles of natural justice. Because what if the judge in your matter had a I mean, you had given a loan to that judge, and simply you can go up to that judge and be like, I'll waive off your entire loan if you rule in my favor. Isn't that a monetary bias? We call that as pecuniary. Pecuniary means money related. Money related is known as pecuniary. Okay, so any kind of a monetary relationship that the judge has is known as a monetary bias or a pecuniary bias. Okay, wonderful. So that means a judge who is having some kind of a loan or has borrowed something against you, or his family members has borrowed something from you, or some kind of a monetary transaction, cannot be a judge in your matter for the simple reason that he is biased. But it's not always money that matters over here. The second type of bias that we can see is a personal bias. A personal bias, and for this we look at the case law, okay? Mineral Development Limited versus State of Bihar. Very interesting case. Here, a company was owned by a person known as Raja Kamakhya Narayan Singh. Okay, a Kamakhya Narayan Singh was a owner of a company. Now, this company had taken out a lease. So, we'll see a company had taken out a lease. From whom? From the government. The government itself was leasing out this land to Kamakhya Narayan Singh. For how many years? For 99 years. Ma'am, what kind of a lease exists for 99 years? This is usually with respect to mining of minerals. Mining leases will usually be around 99 years. Okay, great. Now, now comes our famous person, the Minister of Revenue. Okay, now this Minister of Revenue came and cancelled the license. Why? What? How? For what reason? Nothing like that. Turns out when we look back in few years ago, turns out that Kamakhya Narayan Singh had opposed the minister in the general election of 1952, and the minister had filed a criminal case under section 500 of the Indian Penal Code against him. So look over here. The minister is saying, now look, today I'm a minister. You are still where you are. Let's see how you continue your mining lease, because I'll come and cancel it. That's exactly what's happened. What has happened over here? Our Minister of Revenue, okay, a Minister of Revenue is a judge in this matter. Okay, he is a judge. He is the one who's given the final decision. What is that decision? He has cancelled the license, right? But look at it. He had a personal bias against Kamakhya Narayan Singh. Was it cancelled for any valid purpose? The answer is no. It was cancelled simply because of a personal bias. Okay, so this is how we see a personal bias involved over here. Now, we can see this in multiple case law, so I'll move ahead. The next one is known as a subject matter bias. What is it? A subject matter bias. Okay, subject matter is nothing other than the fact that um, right. I'll just clarify this paragraph alone for you. It seems to have been some kind of a mistake. A subject matter bias is nothing other than every person has some interests or some kind of a liking or disliking. Now, say for example that I'm a judge, and as a judge, I am a feminist. So the judge is a feminist. And for whatever reason, any woman goes and stands before the judge will rule in their favor. Or let's say, apart from being a feminist, I am pro environmentalist. So if any big companies come before me, no, especially if they are polluting the environment, I will automatically file, like I'll give a judgment against them. These are subject matter biases. It's for no other reason other than the fact that we read books, we read the newspaper, we develop opinions. Our judges are also human beings only. So the judge has to have a clear conscience saying that I am not biased in this matter. Okay, so this is where we can see the case of subject matter bias. Okay, now let's come to the second, I mean, our main one, that is our rule of fair hearing. Now, let me give you a situation. Let's go back to our GST license. GST license was first and foremost, um, let's say the following happened. So we're looking at our GST license. Okay, GST license on 21st December 2025, it was cancelled. I'm going back to our old example itself. Now, it's not always the case that they'll immediately pass an order like this, okay? The actual progression of events will go like this. Let's say on 20th December 2025, a show cause notice, a show cause notice was issued to my GST number. What is a show cause notice? We'll also in short form write it as SCN. Okay, a show cause notice is like a notice where the authorities is sending you a notice saying that show me cause as to why I should not cancel your license. It's like saying that the authority has found some kind of an issue with my license, and rather than going ahead and simply canceling it, they're first sending me a show cause notice, and for the show cause notice I should actually give a reply. Okay. Now, I should tell the GST, no, I filed my returns on time. The GST amount was also paid on time only, but then it got credited to the account a little bit late. So, I am properly within the rules, and therefore, you should not cancel my GST number. Now, this is ideally the reply that I will give. Now, what is the date? 20th of December 2025. But then on 21st December 2025, they passed an order itself. What? An order of cancellation. What do you mean? How can you pass an order of cancellation? But then the government is saying, no, no, we sent show cause notice. You send show cause notice. You have to give me enough time to reply to that notice, right? By the time this notice reached me, it was already the 23rd of December. Before I even got the notice and had a chance to respond to that notice, they passed an order of cancellation. What do you mean by this? Like, how can you call this as a fair hearing? Is there a fair hearing in this case? Fair hearing means it's a reasonable hearing, correct? But our government is saying, no, no, I sent show cause notice and then I sent the order of cancellation. So, therefore, I've done fair hearing. It doesn't make sense because by the time the notice is sent to me, I need at least 10 to 15 days time to prepare a reply and check what is wrong, and then I have to reply, and then only they should pass an order of cancellation. So can you see how just by saying fair hearing, you do not just leave it at that, it has a very in-depth meaning. So what exactly do you mean by that fair hearing then? That is what we will look at here. Every fair hearing involves a right of notice, because only when notice is given, only when sufficient time for notice is given, we can say that the other party can even appear before the court. So a hearing starts only when notice is given. And please remember, sufficient time must be given. You can't just send a notice today and pass the order of cancellation tomorrow. Sufficient time of notice must be given to respond to it. Okay. Now, let's look at the case law of Annamalai Cotton Mills Private Limited versus the chairman of the Tamil Nadu Electricity Board. So, somewhere over here it relates to the concept of electricity. Fair? Okay. Now, what happened over here is that what happens when you don't pay your electricity bill? one electrical officer will come and then he'll pull the plug. The same thing has happened over here. Okay, and now let's look at this. Basically, a notice has been sent to the petitioners, that is our Annamalai Cotton's Mills Private Limited, wherein a show cause notice, a show cause notice with respect to alleged electricity theft. So that means what? The notice is coming and saying you have been stealing electricity. And many people do this. Okay, one electrical line will be going there, they'll go and plug in one clip over there, and then they'll be stealing electricity. It's a very common thing that happens. But then this particular company was sent a notice saying that you have been stealing electricity. Okay, fine. If the government, if electricity board is claiming that electricity is being stolen, then they should give sufficient evidence to support their argument. They should show, see, look, this is the meter reading, or so much was used within so much time, but then you show your electrical meter is showing only like half the amount of units, something like that. But turns out the electricity board didn't give anything to support their arguments. Means they didn't give a meter reading, they didn't give the time period which they're talking about, as well as the authority taking the action. Basically no details, just you have stolen electricity. The court held that the show cause notice was vague and therefore has to be quashed. Quashed meaning, literally, what do you mean by quashed? If you take an orange and smash it, that is called quashed. So that means the court is saying that take this order and chuck it out. It is not valid. This is the importance given to a show cause notice. Now you may think, ma'am, it's just a show cause notice, right? We'll take care of it in procedural way otherwise. No, a show cause notice is the first thing that is very valid. Because if a show cause notice is not valid, then the entire principles of natural justice is being violated. Now, let's say that notice is sent. You have been given sufficient time to respond to it. Now, you should be given a right to present your case and evidence. You have to appear before an authority and present your arguments. Now, this also happens. People will be brought, they'll come to the court and they will not be allowed to talk. The judge will be talking on his own, he'll be talking on the phone, he'll be communicating with his colleagues. Finally, he'll be like, hearing over, now get out. Is that a fair hearing? No. A right to present the case and the evidence. Then the right to rebut the evidence. Remember, I told you, just because I'm giving some evidence, the other party can come and say, no, this is false evidence. That is what you mean by rebut adverse evidence, wherein we have something known as a cross examination and legal representation. Now, don't you think that if such a legal action is being taken against me, I require a legal representation? Like, what if I'm illiterate? Or what if I have no knowledge of the law? I don't know that a show cause notice has to be sent. I don't know that this procedure has to be followed. Or I don't know the court procedures. So, every person is entitled to legal representation. Nobody can be expected to be brought before the authorities and just presume to know everything. Because before we started studying law, even you and me had no idea about legal procedures. So how is the common man supposed to automatically know legal procedures? No, right? So that is why we have something known as legal representation, which is a very crucial part of the principles of natural justice. And then finally, we have disclosure of evidence. Now, in movies and all, right, I have seen this. In movies, to show and build up the drama, the one party will come and give us secret evidence before the court of law, and then the court will look at it and then declare the judgment in his favor. Sadly, that happens only in movies. Okay, because in our own courts of law, if I am submitting an evidence to the court, I should also provide a copy to the other party. Now, if that other party is submitting evidence before the court of law, that party has to submit a copy of it to me also. There is no secret hiding drama happening over here. We have to disclose everything to the judge and to the opposite party. So, what if I only give it to the judge, but I don't give it to the opposite party? There's a violation of principles of natural justice. And our final thing, which is speaking orders. Speaking orders is nothing other than reasoned judgment. I'm not even using the word judgment alone. Okay? I'm not using the word judgment alone. The word that I'm using over here is reasoned judgment. Okay? Please be very clear about it. A judgment can just simply come and say, I am ruling in your favor or I'm ruling against you. But a reasoned judgment will come and say, I'm ruling in your favor due to these reasons. And remember, everything needs to have reasons, because if it doesn't have reasons, then it is arbitrary in nature. And anything which is arbitrary is automatically violating Article 14. So let's quickly go through it again. Okay. What is your audi alteram partem? The rule of fair hearing. But hearing means, it doesn't mean giving show cause notice today and passing order tomorrow. No, it is the right of notice. And the notice time, the time to respond to that notice should be sufficient. As seen in the case of Annamalai Cotton Mills Private Limited, where the court said that the show cause notice was vague, it was not clear. And so there itself, the proceedings came to an end. Then the next one is, once you've been given the chance to present yourself, you should be given a chance to be heard and present your case. Now, when you're giving your case, the other party can rebut your evidence. They can cross examine you. And because the concept is that everything is so technical, even legal representation is a requirement. If a party requires legal representation, then they can get it. Okay. And um, let's just look at the case law of Nandini Satpathy versus PL Dani and others. Basically, here this is a Supreme Court decision. The Supreme Court said that when there is an interrogation, a custodial interrogation means a person has been arrested and taken into custody of the police. The police should wait for the representative to appear. Basically, every accused has a right to have a lawyer present. I think all of us know this, or we're aware of this fact. But you see, the police will allow the lawyer to come in only in the last 5 minutes. No, the police should actually wait, especially if the person is asking for a lawyer. They should wait and allow that legal representative to appear to appear and stand with the accused. Okay. If such legal representation is not allowed, and in many cases, we see it happening, it is a direct violation of Article 22, Clause 1. And this we've already covered in our Article 22, correct? Now, disclosure of evidence, all evidence has to be disclosed. And finally, speaking orders. All the judgments, the judgments given by the judge should be of a rational conclusion. Means basically give reasons. Why did you arrive at your judgment? How did you arrive at your judgment? What did you use? All that needs to be looked at. Okay, so let's look at the case of um, Canara Bank. Let's read it. In the Canara Bank and others versus Debashish Das and others, principles of natural justice are those rules which have been laid down by the courts as giving minimum protection given to an individual against an arbitrary procedure that may be adopted by a judicial or a quasi judicial authority. These rules are intended to prevent the authority from doing justice. So it's a general case law where the court has stated that, see, principles of natural justice is very, very important. Now, quickly, let's come back over here. What can we see over here? We saw that in the court of law, the civil procedure expects you to send notice. Now, does the principles of natural justice also ask you to send notice? The answer is yes. Now, does principle of natural justice ask you to hear both parties? Yes, that is only audi alteram partem. Correct? Then, should the facts be given? Yes. Should the arguments be countered? Yes. Should evidence be given? Yes. Can it be rebutted? That also yes. Is there cross examination? Should the decision be a reasoned decision, a reasoned final decision? The answer is yes. So, can you see how, even though they've said that before the tribunal, the CPC and evidence law does not apply, but the principles of natural justice applies, in a way, we are still following the procedure laid down in the court. But it won't be as stringent as what is given in the civil procedure. So I hope you are understanding um, the concept of principles of natural justice. And let's do a very quick recap of it. In the principles of natural justice, we have two main headings: rule against bias, nemo judex in sua causa. In causa sua. And the second one is audi alterum partem, the rule of fair hearing. Now, in rule against bias, the rule is that no person should be a judge in his own case. And then we go on to identify the different types of biases that are there. It can be pecuniary bias, which is a money related bias, or it can be a personal bias, as seen with the Raja Kamakya Narayan Singh and the Minister of Revenue cancelling his license. And then we also see subject matter bias, which is related to general subject matters. Then the rule of fair hearing says you have to give right of notice, you have to present your case and evidence, rebut that evidence, cross examinations, legal representations, disclosure of that evidence, and speaking orders, which is nothing other than reasoned judgments. So, this is your principles of natural justice. But principles of natural justice has some exceptions. Okay, so what are these exceptions? Sometimes the law will exclude the need for PNJ. It will say that notice need not be given, or arguments need not be given, or evidence need not be given. Now there are multiple examples for us to go and check on this. Okay, sometimes the law itself will come and say not needed. Like, say for example that this is to prevent the use of psychotropic drugs. Now let's say for example that the and like the police, they find drugs over there. Now at that time, do you think the police should first send that drug dealer a notice and then give him a chance to be heard, and then bring him before the court of law, and then allow him to give evidence? No, he'll that drug dealer will take the drugs and chuck it off into the river nearby. Immediately you might be required to apprehend that immediately. So the law itself will come and say, with respect to dealing with drugs, no notice needs to be given. Every police officer has the authority to go immediately confiscate the drugs and dispose of it however he thinks fit. So the law itself can come and exclude you sometimes, and we have to look at the law for that example. So the very first exception to principles of natural justice is if the law itself excludes you. Okay. um, Next one is emergency. Now emergency, I'm not talking about your national emergency or your financial emergency. I'm not talking that way. Actually, in the case of Maneka Gandhi versus Union of India, what had happened was Maneka Gandhi was trying to, the police were trying to catch Maneka Gandhi, and she was trying to leave to a different country. So what had happened was the police had apprehended her at the airport itself, and they immediately confiscated her passport. Now, when brought before the court of law, Maneka Gandhi had a very interesting a defense to be brought before the court. You see, a passport is a very essential document. And if the government is going to confiscate your passport, then first they should give you a fair hearing. They can't, can the police simply come and say, hey, do you have a passport? And you say, yes, I have a passport. He's like, give it to me, I'm confiscating it. It's the same thing. Okay, so that means Maneka Gandhi was saying that you never gave me a notice, you never gave me a chance to present myself, you never allowed me to give my evidence and my hearings, but then you passed a decision against me. What is the decision? The action of taking my passport away from me. It's a very fair argument, right? Because principles of natural justice here essentially principles of natural justice was not followed. That's a big violation of law. But the police came and said, Your Honor, if we didn't confiscate her passport then and there, she would have boarded her flight and she would have left the country. And then this hearing would have never taken place because she would be in a different country and she won't appear before the court of law. And the court also understood that. So, as an act of emergency, the police immediately confiscated her passport. So, to provide a remedy to Maneka Gandhi, the court came out with something known as a post decisional hearing. That is, after the decision is given, they gave her a notice, a right to be heard, a chance to present evidence, to rebut evidence, etc. So, this was a very case, like a specific case basis, which we call as emergency. So, the first one is statutory exclusion, the second one is emergency. Next one is interim disciplinary action. And for this, let's look at the case law. Again, this case law is Abhay Kumar versus K. Srinivasan. Basically, what had happened was the student was having a criminal case against him for stabbing a student. Now imagine you're going to college and then you hear that your college mate has stabbed a student and the police has apprehended him, and currently he's out on bail, but he still has to go to the court of law, and the decision is pending. So don't you think in your college this will cause some kind of fear or confusion or generally fear? So what the college has done is the college has said that I am suspending you until the final decision has been given by the court. So what has the college done? The college has passed an order basically suspending the student. Now can the student say something like, buddy, you can't suspend me without first sending me notice, giving me a chance to be heard, and then only passing decision against me? No, because the purpose of this action was to maintain peace in the college. Interim disciplinary action doesn't require the extensive requirement of your principles of natural justice. This is a temporary exercise of power by the college. What if the college had expelled him? If the college had expelled him, then you can say principles of natural justice. But this is a temporary measure. At that time, you need not follow these things. And the same thing applies to academic evaluation. Now, let's say, for example, that you are going in for your ICSI examination and then you finish writing your paper. Now, it is February 25th or August 25th, as the date may be. And now, this is only an example. I hope all of you all get 80 marks and above in each one of your papers. Okay. But let's say that you get your answer sheet and it turns out you have failed. You've gotten only 25 marks. Now you think, oh, I've studied principles of natural justice. Let me go and ask my teacher, how dare you fail me in my paper because you never gave me notice? You never asked me, you never asked me why I wrote the answer wrong. You never asked me if I knew the answer. How can you just fail me like that? Do you think that happens in any kind of examination? Obviously not. If you write your answer sheet, you either fail or you either pass. You don't go and ask for principles of natural justice at that time. That is only what we call as academic evaluation. So, there's an extent to which principles of natural justice can be applied. And then, lastly, impracticability. So, in impracticability, we look at this case law P. Radhakrishnan versus Osmania University. So, what happened in this was the entire MBA entrance exam was cancelled. Why was it cancelled? It was cancelled because there was mass copying. Okay, so it got cancelled. Now, all the MBA students went ahead and said that how can you cancel without giving a notice first? And that is fair. Imagine you go for your ICSI examination, you're standing over there in the examination center just to find out the examination has been cancelled. You've not been given prior notice of it, nothing. So at this point, technically you should be given a right of notice, but it's impossible to send it out to lakhs of students who are appearing, right? How do I send out a notice to each and every one of them? It's just nothing other than impractical to do so. That time principles of natural justice need not be followed. Okay, so what are we looking at with respect to exceptions to principles of natural justice? There is statutory exclusion, emergency, interim disciplinary action, academic evaluation, and then finally impracticability. So, friends, I hope you're clear with this concept of principles of natural justice.